and ask members and those in the public gallery to turn off any electronic devices except the members' tablets, which are to be switched to mute mode. Okay, thank you very much. Can we seek agreement that item 4 will be recorded by Hansard? Agreed? Agreed. Thank you. We have an apology from the Chair, Dahi McKay. Any other apologies?
Paul?
Paul is going to be late.
Yes.
Michaela is running a wee bit late as well.
Thank you. Okay. We'll proceed then to item number 2, draft minutes of proceedings, 25th of March. These are pages 5 to 9 of the packs. Can I ask our members content that the draft minutes are an accurate record of proceedings? And if so, do members agree that this should be published in the Assembly website?
Agreed.
Thank you. And item number 3 is matters arising, table of requests for information from DFP. Summary table of requests for information from DFP at pages 11 to 14 of the packs, and they are there for noting. So with members' agreement, we'll move on to item number 4, which is DFP officials on dormant accounts. This session has been allocated around 40 minutes and should be completed by around 10:55 or thereabouts. And this item is being recorded by Hansard. I will remind you once again to switch off any electronic devices. Okay, so the background to this is a DFP briefing paper on the Northern Ireland Social Innovation Fund is at pages 16 to 19 of your packs. And I'd like to welcome the witnesses, Emer Morelli, Head of Supply, Public Spending Directorate of DFP, and Mary-Ann Smith, Supply Division of DFP. Very welcome, ladies. And can I invite you to make an opening presentation?
Thank you, Chair. Thanks to the committee for this opportunity this morning to appear before you on the Dormant Accounts scheme. The background paper set out some of the detail, and I'd just like to rehearse some of the key points. The Dormant Accounts and Building Societies Act 2008 makes provision for the use of monies from dormant accounts and building society accounts for social or environmental purposes. By way of background, following the 2008 Dormant Accounts Act, banks and building societies can voluntarily transfer account balances that have been dormant for 15 years or more to a reclaim fund. The reclaim fund is a private body managing private funds. It is authorised by the Financial Services Authority and was authorised in March 2011. The transfer to the reclaim fund by banks and building societies is discretionary. The rights of legal persons entitled to dormant funds who are subsequently identified is preserved. The 2008 Dormant Accounts Act also provides that the Big Lottery Fund shall distribute dormant accounts monies for meeting expenditure that has a social or environmental purpose. It is the Reclaim Fund's responsibility to determine the amount to be transferred to the Big Lottery Fund. The money transferred to the Big Lottery Fund is then apportioned between England, Scotland, Wales and Northern Ireland according to a set formula that has been agreed by the Westminster Parliament. Government ministers in Wales, Scotland and Northern Ireland have the power to give the Big Lottery Fund legally binding directions as regard to the use of the transferred funds. The Minister for Finance is responsible in Northern Ireland. Now, there are currently £6.423 million available for Northern Ireland spending priorities. The distribution of money for meeting Northern Ireland expenditure is set out at Section 21, subsections 1 to 4 of the Dormant Accounts Act. This requires that any order made under this section of the Act is laid before and approved by a resolution of the Northern Ireland Assembly. This means that the proposed way forward in respect of the use of the dormant accounts money must be subject to consultation. Now, you will be aware that the utilisation of dormant accounts money has already been subject to public consultation in 2009. This consultation focused on restricting the purposes for which or the kinds of persons to which the distribution of dormant accounts money could be made. The outcome of the consultation was not conclusive and not published. A further consultation exercise was undertaken in 2012. This exercise was to determine the level of interest by potential fund administrators. The consultation ended on the 2nd of November 2012, and the outcome of that consultation demonstrated a significant level of interest by potential fund administrators in Northern Ireland. Following consideration of the previous proposals, and subject to the outcome of a future consultation exercise, the Minister for Finance has decided that the spending priority in Northern Ireland should be raised to social investment in general. It is the Minister's intention that, subject to the outcome of the consultation, this will be distributed by the Big Lottery, who may appoint a third-party distributor in Northern Ireland to manage the Dormant Accounts Fund, with the potential to provide match funding, and that the available monies will be used to provide loan funding to social enterprises, community voluntary groups, etc. As announced by Minister Hamilton as part of Budget 2015 and agreed by the Executive, it is his intention that this fund be established in 2015-16 and known as the Social Innovation Fund. We are happy to take any questions the committee may have.
Okay, thank you very much, Emer. The paper mentions that there be 6.4 million available. Is there any likelihood of additional money becoming available in the future? And if so, have you any estimate of how much that might be?
There is potential as further accounts are identified as dormant and brought into the general fund by the Reclaim Fund. This is likely to be significantly less than we've had to date because the majority of funds have been identified and brought forward. But indications are Northern Ireland will continue to get a 2.8% share of whatever additional comes forward, but we wouldn't know the quantum at this time.
Okay. This money, by the time anybody receives it, will have been well travelled. I note that it's going from the banks to the Reclaim Fund, then the Big Lottery Fund, and then to a fund administrator and so on. Would it be worth anything at the end of the day?
The administration costs.
No, sorry, I'm joking. The question I want to ask is there no way in which that movement of money can be streamlined, which obviously would speed things up a lot?
Well, I think by raising the priorities to social investment in general, the Minister has taken a significant step forward. And subject to the outcome of the public consultation, the monies should be available in 15-16 with the establishment of the fund in Northern Ireland.
No, I don't dispute that. But yes, what I'm saying is, does it have to go through all these hoops? Why does it have to go through all these hoops before it gets here?
It's the legislation is set out in a very prescribed way, with requirements, for example, that the Assembly here has to approve the distribution of the monies in Northern Ireland, etc. Other schemes are in place in England, Scotland and Wales, which potentially we could link into, subject to the agreement of the Assembly, but the consultation will give us that outcome.
It just seems to have to travel a long and tortuous route. But anyway, perhaps that's something that could be dealt with and views expressed in the consultation. The areas of focus under the Social Innovation Fund, is there any indication of what they might be?
Well, at the moment, it's really to provide loan finance to community voluntary groups, small enterprises that are dealing with social or environmental issues. In Northern Ireland, I suppose social enterprises would be a key area where the monies could potentially go. But again, it will be subject to the outcome of the consultation. Youth groups, children's groups would be key areas that have benefited in the rest of the UK, and it would be expected that they would benefit here too.
When you say small enterprises might benefit from it, do you mean by that small enterprises which are small social enterprises?
Absolutely, yes. It has to have a social element to it.
Okay.
Yes.
Aside from the various exercises and the Minister's decision that the spending priority should be social investment, in general, why has the whole exercise taken so long?
Previous consultations, I suppose, sought views that the monies would be restricted in Northern Ireland to two specific groups, children's groups and those faith-based organisations who weren't able to access routine Big Lottery funding because of connotations and associations with gambling. That consultation was not conclusive, and by raising the priority to social investment, it widens the opportunity now for a range of community and voluntary groups to access a very significant funding source in the current budgetary climate.
Did you say that the outcomes of that consultation were not published?
They weren't agreed, and hence not published. And as so far as that a final position as a result of the consultation was not agreed.
And when you say they weren't agreed between whom?
Well, under the pre-consultation, there was no one consensus of opinion. I understand the committee discussed this issue as well, and there was differences of opinion here. There wasn't a clear solution at that time to move forward. And by raising it now to social investment, there's an opportunity to use the money in Northern Ireland.
Okay. What's the timetable now for the completion of the actions as you've lined out in paragraph 14 of your briefing paper?
At the moment, the department is in pre-consultation. We're talking to the key stakeholders, the big lottery, other interested parties, in order to finalise a consultation document. And subject to the Minister's approval, we would hope to publish that by early summer for the routine 8 to 12 weeks. Conscious that over the summer we might need a little bit longer. After that, then to bring the conclusions back to this committee and then into the Assembly.
Okay. Can you tell us what will the process be for the appointment of the third-party distributor?
Well, at the moment, we're in discussions with the Big Lottery. We have to, under the legislation, consult with Big Lottery before that process is finalised, but that will be also included in the consultation.
Okay.
Will allow us to move forward on that.
And can you give us any indication of what type of our group or organisation, might be eligible to be a distributor?
Well, the Minister's preference at the present time would be for an organisation that would have the potential to bring match funding into the fund. So if we have 6 million, if there was an opportunity to increase that in any way through the third-party distributor and make more monies available. I suppose the intention of the fund per se is that it will become self-sustaining. The fund is outside public expenditure monies. So any additionality would only be of benefit to the groups that are eligible to apply.
When you say that the distributor might be or may be appointed on the basis of the possibilities of bringing much funding to the table, are you saying that the distributor would provide the match funding, or the distributor would help to access much funding for groups which apply?
Probably either option. Again, we're going to tease that out further in the pre-consultation stage, and it will be subject to consultation. But the option is really to get loan finance into the system.
I'm not aware of any distributor of funding which also applies or provides match funding. It's usually a distributor providing money will require the applying group to access match funding from another source.
That is one potential option, but we're also looking at models that are in place in the rest of the UK. In England,
and can you give us some
yes.
examples of the
yes.
models that are based in the rest of the UK?
Well, in England, the monies have gone to Big Society Capital, who have now set up an Access Growth Fund. And within that fund, other potential investors are coming into the fund to supplement the monies that are there, making, therefore, more monies available for application.
And when you say other investors are coming in, what type of organisations, groups or whatever are they?
Well, I suppose these are organisations that have an interest in social investment. It's a growing market across the UK where there's a social benefit plus a financial benefit under the scheme.
Okay. And when you say that the aim is that the fund will be self-sustaining, Would that be self-sustaining from the sort of continual flow of monies from dormant accounts?
No, self-sustaining from the structure of the fund itself, in that loans would be provided and repaid, therefore making the fund itself a self-sustaining fund. As I say, the reliance on additional money coming from dormant accounts, there will not be significant sums coming through. That's our understanding.
Right, so the distributor will be giving out loans?
That will be the intention.
Yeah,
Yes.
right.
But this is all subject to the consultation exercise.
Right. And, is that a common model where the distributor gets, provides loans and the applicant seeks match funding?
It's not necessarily the applicant seeking match funding. Under the model, if there was a fund administrator or whatever, the applicant would get the loan per se and spend that loan and repay it.
All right, okay. Thank you.
Again, just to stress, it's all subject to further consultation, and
Yes.
different options are being discussed and developed at the moment.
Okay. Thank you. And Leslie?
Thanks, Chair. My question is really to do with this area we just touched on. These are really loans, they're not grants. So what is the likely interest rate going to be in those loans? Will it be a commercial rate?
Given the nature of the loan, and to make it, I suppose, beneficial, would probably be below a commercial rate. But again, all of that has to be discussed and worked through.
We have been consulting here for the last 6 years on
Yes.
it. It really is. It's a small book now, isn't it? Will there be interest paid anywhere along the chain, apart from the end of it?
No, not under the models that we're looking at.
No. And the final fund administrators, will they be paid a fee for their services?
It depends on how we structure it. But
Yes,
again,
that's what I'm asking
yes.
you.
Well, yes, well, we're currently working through that at the moment.
The
But
legislation allows, yeah, for
an administrative fee.
So they may be working then simply at this exercise.
Sorry. Are you finished? Leslie?
Yes, I was just making quite clear there, that the end fund administrator will actually be paid. That's the point.
Right. Okay.
That didn't come out just in the paper, but that's. Thanks
No,
for
the
that
legislation clearly allows for the expenses to be.
Yeah, but it's what's actually happening, so that's what you envisage.
But, we have here the Ulster Community Investment Trust already, and are you not proposing to duplicate some of the work that they already do?
There's a potential for the UCIT to be part of this as well.
Right.
So it wouldn't be a duplication.
So they in theory could be a possible distributor.
Yes.
Yes, but again, subject to the outcome of the
Subject to
consultation.
consultation, of course.
Yeah, the
Yes.
2012 consultation identified a number of people that might be interested, including Charity Bank and UCIT, so it would be subject to
Right.
type of
The
independent process.
legislation also requires full consultation with the big lottery
Okay.
before we proceed.
Yeah.
And would the big lottery be a potential distributor
Yeah, well, under
They
the
could-
legislation,
yeah,
yes.
yeah.
under legislation? Yeah.
I think that's still
Right,
under
okay.
discussion as to whether it goes to a third party, but I
So
think
there are
Minister's
a
keen.
growing number of options. Okay, Adrian.
Could it be possible that this would be a social business that would deliver the third party of it? Like a community organisation of some sort.
Yes,
And any interest that we charge the loans will go back into that community organisation.
yes.
I think that's the model we should be looking at, something like that.
So we're looking at a number of models
Yeah.
at the moment.
Yeah.
You're saying the interest will go back into the fund, obviously.
Potentially, yes.
Yeah. Okay, any other questions? Doesn't seem to be any others, so thank
We'll wait the
you.
results of the consultation, Chairman. We'll wait the results of the consultation.
Yes.
We'll be back.
Okay, thank you. And Mary Ann, thank you very much for
Thank you.
attending today. Right. Given that the officials are not here at the moment for the next session, we'll move on now and deal with correspondence. And that's at pages 40 to page 40 of your packs, I think. And I'll ask the clerk to talk us through some of it.
Okay, Chair, I'll just pick out the items of correspondence I think made decisions. Just on the first item there, page 40 of the pack, the Secretary of State's responding to the committee's letter regarding concerns around implications of the Corporation Tax Northern Ireland Bill Act in relation to building societies and following some representations from the Progressive. So it's just an explanation around the provisions in the bill in relation to that. It's just to seek agreement to copy that correspondence to the Progressive, just for information in terms of closing the loop on the.
Members agreed?
Then there's correspondence at page 57 of the pack in relation to employer-employee contributions in public service pension schemes. Just it applies, it's relevant to other committees in terms of the various schemes, so it's just to seek agreement to forward that to the other applicable statutory committees for information.
If you have a look at that, there's quite a difference between the employer contribution with regard to the judiciary in relation to in comparison to for example, the civil service, the police, the fire service. They average around 20%, yet the employer contribution for the judiciary is at 38%. And that seems to be quite a difference. So the members agree that we should write to the department and ask for an explanation of that difference. Okay?
Okay, Chair. There's correspondence then at page 61 from DFP in relation to the Northern Ireland Housing Executive pay increment. The committee had received communication from an employee regarding delays in that regard, and DFP is just explaining that the delays weren't in terms of its role, weren't on its part. It responded within the appropriate timescale. So it's just for copying to the Social Development Committee for information. Given the cross-cutting nature of the issue, if members are content.
Agreed.
And there's correspondence from DFP at page 66 of the pack in relation to the various queries the committee had raised following the last briefing on the voluntary exit scheme, the NICS voluntary exit scheme. The committee at that time decided to schedule a briefing on the overall schemes across the wider public sector. So just in terms of the protocol around this, if the committee's agreed, just that the chair writes the head of civil service seeking that oral briefing on the public sector workforce restructuring steering group and the wider schemes, and copying it to the WFM-DFM committee for information, Chair.
Agreed.
Then there's correspondence from a member of the public in relation to the PSNI NIO equal pay issue. The committee has received various correspondence on this, and the department has responded also. In the pack there's communication from the department to a similar query at page 43 of the pack. So the department's basic position is that the issue rests with the executive, and unless and until the executive agree to consider the issue, the department as itself can't progress the issue any further. So it's just really in terms of this piece of correspondence at page 77, if members are content to forward that to the department.
Agreed.
That's then there's an invitation from Chartered Institute of Public Finance and Accountancy to the annual luncheon on the 15th of May at Belfast Castle. That's at page 79 of the pack. So it's for members to respond directly should they wish to attend that event. There's also Assembly Research provided a recent publication on potential proposals around regional devolution in England, which is relevant to the committee's review of the Barnett formula. So it's just really to note that as part of the evidence base, it could be referred to if the committee, if there's issues of relevance to the committee's deliberations in the forthcoming committee report, Chair. I think that's all the correspondence requiring decisions, Chair.
Can we move on to the press release under any other business? There's a copy of a press release provided at the pack there, in the pack. I think it's on the back of it, is it? Or,
Yeah.
it's in advance of the debate on the report on sickness absence in the Northern Ireland Public Service, and that will take place, as you know, on Tuesday 21st of April. Members are encouraged to contribute to the debate, and hard copies of the report are available here today, if you haven't already got one. I'll give members a few minutes to peruse the press statement and then ask for approval. So can I ask members, are members in agreement with the press release being issued?
Yeah, happy enough.
Members happy? Yeah. Thank you. Given the fact that the officials for the next evidence session have not yet arrived, I'm going to suspend for 10 minutes, so I'll give you the opportunity.
This is the Northern Ireland Assembly.
The agenda, the rating of commercial window displays, and we have a briefing schedule from department officials, and the relevant sections in your pack are at pages 21 to 25. So I would invite our witnesses, Brian McClure, Head of Rating Policy, Central Finance Group, DFP, and Brian, you're not accompanied, no?
I'll go solo
Right,
on this
okay.
particular item, Chair, and Philip Collin will join me for
You're very welcome back
the
again,
session. Thank you very
Brian.
much, Deputy Chair.
And whenever you're ready, you're welcome to make an opening statement.
Okay, thanks very much for this opportunity to report back on a policy proposal that came to the Minister from the business sector. It was actually Mr Peter Murray, who's manager of Buttercrane Shopping Centre in Newry. He asked the Minister to consider changing rating legislation so that empty shops could be used to display goods, and to help enliven shopping centres that had a lot of empty shops, or for high streets or whatever.
Yeah.
And the Minister offered to take this forward, and we have undertaken a targeted consultation which ended in January, and I'd like to report back on that and take the committee's views on the proposal. As you know, Northern Ireland has a higher level of shop vacancy than anywhere else in the UK, and the Minister was very keen to try and take some steps to help address that. We've already taken some measures through the rating system with the empty shops concession, and this is a supplementary measure that the Minister would like to take forward. It will require a change to primary legislation. However, we do have a rates amendment bill on the legislative programme, and this is one item that we would like to include in it. One of the other items, which I won't discuss today, but I will discuss at a later stage, is to do with the issue of community amateur sports clubs, which, as you know, Daithí Mackay had put forward a proposal for a private members bill. The Department is prepared, however, to take its own legislation through on that, and I'll discuss the issues around that at a later session whenever is convenient for the committee. But this particular issue, as I say, was developed as a way of helping to improve the appearance of shopping centres and the high levels of vacancies. It's a micro policy. We're making no claims that this is going to solve the issue of empty shops. It's a much deeper issue than that. but we believe that it can help. The consultation concluded on the 9th of January 2015. We asked people, did they agree with the proposals? How could it be designed to prevent abuse? How to avoid an unfair advantage to some traders, and what impact it could have on other forms of commercial advertising. And I think the committee has the consultation report on that. The key themes emerging from the responses were that all respondents broadly agreed with the proposal. A number felt that the scheme could help address the problems with empty shops on our high streets and shopping centres, and also provide more attractive and vibrant shopping areas. On the issue of potential abuse by ratepayers wishing to avoid paying rates, a number of suggestions were made to combat this, including no public access to the shop, and no point of sale facilities on site, and restricted lighting displays. And all of these matters can be addressed in subordinate legislation. For the time being, what we would like to do is get the committee's views on it as a concept, and take an enabling power in this forthcoming rates amendment bill. Some of the details we will address in subordinate legislation, and again we'll come back to the committee to take its views on the mechanics of the scheme. It's worth saying that the Ministerial Advisory Group on Architecture and Built Environment thought that there should be quite stringent rules associated with this scheme, and the shopping centre managers should be given responsibility for monitoring it. That's not something that we think is going to be terribly workable. We'd like to make this scheme as simple as possible for LPS to administer, and whilst we can see the merit in having very strict rules around it and the administration of that, we believe that if we try to over-engineer this scheme, it will not operate well. I think that's a kind of broad outline of what we hope to do.
Thanks very much for that, Brian. Can I ask you a few questions? First one is, are there any conditions? I mean, you did mention two conditions there, the restriction against public access, and you also mentioned that restriction against a point of sale on the premises, and I can see obviously why that would be the case. Presumably the shops would belong to the shopping centres. Would they be renting them to customers? Are there any restrictions on the type of customers that can use this? Do they have to be charities or have a charitable function?
We believe we need to confine it to those that are currently paying. We need to confine the disregard to those currently paying empty property rates of 50%. So what this scheme will do will be to disregard the fact that somebody's actually making active use of the window display, because occupation of part of a property under rating law means occupation of the whole. And if we didn't have this disregard, what that would do would be trigger a full liability. So that whoever owned the shop would have to pay full rates if somebody was using the shop window to display goods. What we're saying here is, let's ignore that use and therefore avoid any full liability. That person would still be liable for 50% empty property rates. So right. It wouldn't be targeted. We would actually like to exclude those that don't pay any rates. We want it to be a disregard for those that are liable for 50% empty property rates, so they don't fall liable to full rates.
So would it be solely at the discretion of the property owner who they would allow to display goods in the window?
Well, we haven't made a final decision. Our current thinking is it is best not to interfere with that, to just allow property owners to decide, because otherwise, if we are to make certain stipulations, it makes it very difficult for the scheme to be operated effectively. And it is an issue. This whole issue of favouritism is an issue that you could get well, I'll let my brother-in-law in to use, to use my empty shop, but I won't let the guy next door. You know, there are issues there, but to try and overcome that, I think would be very difficult in legislation.
Yeah. And can I just clarify again, would the property owner be permitted to charge for the use of it?
Yeah, I think it could have. Again, this is another policing issue. This is, we could stipulate there would be no charge, but once you start introducing rules, people start working around rules, and we think that it would be very difficult for LPS to try and police whether somebody received a payment or not. And with our view, and I'm only describing what our current thinking is, that we shouldn't interfere with that. We should just allow it, whether somebody pays for it or not. It would be restricted in a similar manner to the current window display disregard for non-commercial use. So it would be the first, say, 1.5 metres of a shop that its use would be disregarded.
Okay. So that's just the area around
Yeah.
the window.
Yeah.
Okay. I see a note from the responses that there were a majority, if not all of them, were positive.
Yes.
So what are the next steps?
Well, the next step would be, because this overrides a fundamental principle of rating, that occupation of part of a property is occupation of the whole property. This needs to be taken through in primary legislation. So what we would like to do, subject to the views of this committee, is put an enabling power in this forthcoming rates amendment bill to allow this to happen. Okay.
And have you any time frame for that?
Well, we would hope that a measure such as this could be taken through very quickly. We will, I think.
You mean the bill?
With the bill, yeah. we think the bill will need to be taken.
When would you expect it to come to the Assembly, for example?
Well,
Before the summer?
The drafting's not finalised, so it would be before the summer.
Before the summer, okay. We mentioned there, whether owners should be permitted to charge or not, and you said issues of favouritism and so on and so forth, and you said that the department preferred not to get involved in the policing of those type of things. Have you considered that the landlords of empty premises, may use this to exploit businesses? Have you given any thought to that at all?
Well, we think by ensuring, we would have certain rules such as no public access, that the depth of the shop would be defined in the legislation, that there would be no point of sale, that those are the sort of rules that I think, unless...
Just clarify, so you say the depth of the shop, what do you think in relation to that? Just
the depth of it could well be, I believe the current window display disregard for non-commercial use is 1.5 metres. Into a shop that you could use. That's the depth from the front window to a depth of 1.5 metres that could be used for window display.
There's no restriction on, shall we say, the physical size. I mean, obviously, shop windows could vary massively in terms of things. Okay.
Yeah. We also believe that it would need to be associated with a business in the vicinity.
In the vicinity.
That is trading in those goods. Otherwise, it just becomes an advertising opportunity. We think if this measure is to work and not be abused, that we would need to associate it with another business in the vicinity.
Whenever you say vicinity, Brian, sorry, Chair, for something. Do you mean in the shopping centre?
It could well be in the shopping centre or in the same row of shops or whatever.
Right, okay. I mean, obviously, there will be an amount of rates that you will forgo in this process. Is there any means of calculating the benefit that this will bring against the amount of rates that the department will forgo?
Yeah, it's very difficult to predict what the take-up of this will be, and I suppose in a sense, if we didn't have this disregard, people would just let the shops lie empty, and you'd only get 50, yeah, and you'd still get your 50% rates out of it. So depends which way.
Surely you would like it to be more than simply a cosmetic exercise.
Well, in a sense, it is a rather cosmetic exercise. This is a micro policy to help the appearance of high streets and shopping centres, and to give the appearance of more commercial vitality. And
But I mean, even in projecting that more positive image within within a shopping centre, could encourage potential leasees to give more consideration to that area than they otherwise might do.
yeah, we think it will help shopping centres. I mean, that's why the proposal was put forward. Peter Murray of the Buttercrane Shopping Centre, it's a problem for him, the amount of dead frontages that he has in that shopping centre, and therefore, if he were to be given this concession, it would allow the shopping centre to be, to work better, to be more attractive to shoppers.
Yeah. Just in the response to the consultation, I see that Ballymoney Borough Council felt that a third party should manage the scheme. What's the department's view on that?
Again, another complication. We like to keep things as simple as possible, because this is not a big policy. This is not a costly policy. And we think, therefore, that to be proportionate about it, we need to have it with as few rules as possible.
Okay, thank you very much. Adrian?
Yeah, I was just going to ask a wee quick question, Brian. Do you see this policy as detrimental to actually letting the premises in the long term?
No, I think it'll help, because I think if anything that makes a shopping area or a shopping centre more attractive to shoppers will improve its marketability.
Well, somebody was saying the landlord's getting nearly enough to cover their 50% rates that we'd be paying on the property anyway. What would give him the incentive then to go out and try and get a full-time tenant in there? Yeah, I know we'd get a few more pound in rent, but he wouldn't be turning backside him, still to go out and let it.
Well, he would forgo, if he's got the incentive of getting a rental income.
Aye.
So I mean, I think that would be the more important consideration for a landlord. Now, this is a novel policy. This is a new policy. As with all policies, we can see how it goes. We can review it, and as we do with all policies, we've always undertaken policy evaluations. And this is something that we can evaluate after a year or after 2 years to see whether it has had whether it distorts the rental market in any way, or whether people use it as a means of avoiding paying full rates.
Okay, thank you. Any other questions? Well, can I ask, are members broadly content with the policy, subject to any other changes that the department might bring forward?
Agreed.
Agreed?
Now, we'll certainly be writing to the committee soon when we get a clause put in this bill, and the committee will be able to scrutinise that. The details of the scheme will be set out in regulations, and again, the committee will have the pleasure of reviewing those. So.
Okay. Well, members, Brian will be remaining as a witness for the next session, and that's on the rebate replacement scheme. And when Brian's ready, hopefully he will give us an initial statement. The relevant pages are 27 to 38 of the packs. An extract from DFP consultation paper providing more information on models A and B are in the table pack. Brian, when you're ready, Brian has now been joined by Philip Conlon. You're welcome, Philip. And whenever you're ready, we would welcome your opening remarks on this particular issue.
Well, thanks again for the opportunity to update the committee on the results of this third consultation on a new rate rebate scheme, although this is the first on the long-term scheme. What I'm going to talk about today is the consultation outcome and what our current thinking is. As with the window display issue, we still haven't finalised the fine detail of this policy. But what we are looking for is the committee's views on whether the main proposal, whether you would agree with the direction of travel on the main proposal.
Can I ask you just give us a brief synopsis, comparative synopsis of models A and B?
Yep. Well, Model A is tied to universal credit, and the principle is that the claimant for a rate rebate will apply for universal credit, and then we will use the information contained in the award notice to calculate an entitlement to rate rebate. Model B is the model that is a refinement of the model that was developed as the interim solution, which has its own means test and uses some elements of universal credit and uses some elements of housing benefit. And Model A, the thresholds we will use are the maximum amount under universal credit, and then we will have various tapers and adjustments for those whose income exceeds that. And we think that is a better way of, in the future. I mean, the reason we are doing this reform is not because we just want to improve rate rebate, it's because of the arrival of universal credit and the removal of all the passporting benefits that the current rate rebate scheme relies on, such as job seekers allowance and employment support allowance and all the various others for those of working age. And I would emphasise what we're talking about this morning is only for those people of working age. The entitlements for pensioners will be wholly unaffected by the proposals we want to talk to you this morning about.
Are you keeping an eye on the rollout of universal credit in GB?
Yes, we'll be very much are, and I suppose the delay in implementing universal credit throughout the UK has afforded us the opportunity to go for this longer term solution. If you recall, we were forced into the position of having to get interim solutions because of the imminent arrival of universal credit throughout the UK, and that has been a lot slower than expected. So this has allowed us to take a more strategic view of things and try and find a better way of awarding entitlement to claimants without asking them to fill in additional forms, without asking them to provide further evidence. I mean, in terms of the consultation outcome, there were 11 responses to the consultation, but as you'll be aware from the previous consultations, those were from the advice sector and the welfare rights sector, and all the big players associated with that have responded. So we're very happy with the level of engagement that we've had in relation to that. In terms of what people told us, there was practically universal support for option A, with the qualified support from Disability Action and NILGA, who we believe didn't fully appreciate what we were trying to do in relation to rate rebate, and I've since corresponded with Disability Action. Disability Action were concerned that what we were doing would somehow disturb entitlement to disabled person allowance, and there's no question of that happening. And they were also concerned that some of the rules that we would be associating with this new rate rebate scheme would somehow disadvantage people with disabilities, and that's certainly not the case. And I've written to Disability Action, and they've welcomed our clarification on that. So the outcome of this consultation was one of practically universal support, but qualified in some cases. There are various aspects to our policy that they have quite rightly questioned: our approach to change in circumstances, our approach to overpayments, our approach to backdating, and so on and so forth.
Yeah, just to go back to the situation across the water, I mean, there seem to be huge problems there with the computer system and huge costs as well, and I think the indications are that some rollout of universal credit has begun. Have you any indication of a time frame when we would arrive at the actual period of implementation here?
Well, we believe the first universal credit claims will be in the Rebate pilot, which was scheduled for March 2016, and the numbers involved are very small. I think they're projected around 50 or so. So it's a very slow start, and that doesn't begin until March 2016.
And any indication of how long the process in total might take thereafter?
I think the initial pilot is for 6 months. I think then they'll start taking new claims. That'll be for about 18 months. And then they'll start to migrate. And I think the migration will also be over an 18-month or 2-year period. So overall, I suppose
talking
about 4 years.
We're talking 3 to 4 years before full implementation,
That's right,
and possibly longer.
Yeah, but we have to start now in redesigning rate rebate, because there's a substantial lead-in time, and we still have to have our systems available for the first wave of universal credit as well. So, kind of 2 years, we're allowing, well, it's actually 28 months in terms of allowing LPS time to develop its systems, processes, training, and so on and so forth.
Okay. You say the Model A will result in around 16,000 people no longer being entitled, but will take in an additional 45,000. Yes. What sort of profiling or analysis have you carried out in terms of the impacts that this will have?
Yeah. The Analytical Services Unit and DSD have been working with us using the policy simulation model, Northern Ireland's policy simulation model, which draws on the Family Resources Survey, and we have identified the sort of groupings that you have mentioned. In relation to that, we can talk you through that if you like. Our assessment of this is that there are good reasons why these 16,000 wouldn't be entitled to rate rebate. We don't believe there would be people would miss out from entitlement to rate rebate that are unable to pay rates.
Well, the people who miss out are the people who won't be entitled to universal credit, because we've tied ourselves so closely to universal credit and Model A. And really, you can split them into 3 groups. Really, one is a group that will have too much income. The other is too much capital, and the other is because the model builds in a number that they think won't make the claim commitment. That's necessary under. Pardon me.
Sorry, what was the third group again?
The claimant commitment. Those that have failed to make the claimant commitment.
Universal credit requires that you commit to various employment-seeking tasks.
Okay.
They assume that there will be a certain number that won't do that.
Can I ask you about the low-income rate relief that will no longer exist after this? What levels of savings would be realised as a result of that? And have you offset that against the cost of the models outlined?
The savings in relation to those of working age, were we to remove low-income rate relief today, would be about $3.5 million a year. So that's the scale of it. In terms of would that money be recycled? Well, we believe it would be recycled, but that's clearly a matter for the executive to decide. All we're concerned about today is not the level of funding, but the actual assessment mechanism. We believe the level of funding is something for the executive to take a strategic view on this in the context of wider welfare reform.
Yeah. Okay. 7 of your respondents to the consultation felt that it was necessary for a hardship scheme to be established. What's the department's current thinking on that, and what level of resource would you envisage would be required if such a scheme were to be adopted or introduced?
We believed, well, I think from a policy perspective, we wouldn't be in favour of a discretionary hardship scheme, but we recognise that there will be calls for that. And we recognise that there were consultation responses that were in favour of that. So what I would say is we have not closed our minds to a special hardship scheme. But I think in order to answer those questions, we need to understand the outworkings of the Dormant House Agreement in relation to transitional arrangements, in relation to wider welfare reform, and what some of these other discretionary schemes are going to do before we look at devising a special scheme for rate rebate. So our minds are not closed to this. I would say, asking me as a policy person what we think of discretionary schemes, we don't think they're terribly effective. There are others in the advice sector who agree with us that they're not terribly effective. There may well need to be something, however, just in case somebody slips through. But from a policy standpoint, we're not terribly in favour of that. But we need to see how these other schemes that come out of wider agreements on welfare reform, what they look like before we can advise on that.
Well, that leads on to the next question. All of this is subject to agreement in the executive on welfare reform. Would that be fair?
The welfare reform bill has to come through the Assembly to transfer the legislative competence to DFP. Okay. At the moment, we reside within social security legislation, but the welfare reform bill does include a clause that puts it under the rates order and therefore puts it under DFP's authority.
Okay. Michaela?
Yeah, thank you, Chair. Brian, my question's kind of almost been answered around the hardship scheme. Appreciating the work that you have done with Disability Action, and it's just on that around a discretionary payment that the Deputy Chair mentioned. Obviously that there would have to be some consideration given to a hardship scheme, particularly a discretionary payment scheme for people who are working and pay their full rates and, you know, for reasons have to come away from work and go into employment support allowance and can no longer afford that. So I think that's something that due care and consideration should well be given to, because
yes, and I would agree with that, and we will do that. But I'm just in outlining my thinking that we're not terribly in favour. I'm just outlining what I say our current thinking. We need to see what happens elsewhere before we can decide whether there's the necessity to have one.
Yeah, no, I appreciate that. It's probably too early to clarify. Yeah, thank you.
Okay, thank you very much. Any other questions? Brian and Philip, thank you very much for your input today. And if there are any other issues that arise, we'll be in contact with you about those, and I'm sure that you will keep us up to date on any changes that may take place. Okay?
I just ask, we're not expecting the committee to give a view on this today, and I'm sure you might want to take the views of some of those that we have consulted. Yeah. But we would be very keen to get the committee view as to whether they like us, favour option A, and like many of the consultees, because we need to develop some of these subordinate issues, and it really requires a high level steer from the committee, and if that's the case, then we can come back on these other issues in due course.
Okay, well, as soon as you leave the witnesses' chair, I will put such a question to the committee.
Thank you very much.
Okay, members, can I ask you if you feel that you have sufficient information on models A and B, and if so, subject to the further negotiations which are ongoing between parties on the issue of welfare reform, can I ask members that do they feel they have sufficient information to come to a conclusion on which model they prefer? I take it that you have. Can I ask members to indicate which model they prefer, Model A or Model B, as I say, subject to further negotiations which are ongoing between parties?
Should we not just believe it until the negotiations are finished?
I would be of the opinion, whilst we have the information in front of us, I wouldn't want to be given an opinion on Model A or Model B at this time.
Yeah, but I'm asking you subject to the, the conclusions of the negotiations.
Sure, why we not wait till the conclusion?
Sorry?
Why can we not wait till the conclusions, And then...
Okay, if that's what you prefer.
I prefer that.
Okay, any other comments? John?
No, I'm fine with Adrian's suggestion, Chair.
Okay. That's grand. We'll move on in that case to the next item, which is the date and the time of the next meeting. We have already covered correspondence. So the date and the time of the next meeting will be Wednesday, the 22nd of April at 10 a.m. in room 30 in Parliament Building. Are members content? I put the question now that the committee will adjourn.